Hi, everybody. This is Arkady Frekhtman, a New York City personal injury trial attorney. And today we're going to be looking at a slip and fall case against a supermarket. And we have the actual trial. We're going to look at a brief snippet of the trial. This is the closing argument. And it was successful. The plaintiff's attorney ended up with a 7-figure verdict. So let's take a look.
Really flowing down into all this. It's two separate components I think she's dealing with. Is not only does it hurt bad, but it's exhausting her too and affecting her mood and energy, and that's why we put on that testimony. And he says, Dr. Downing, would you expect chronic pain? Yes. Dr. Their own expert, I asked him, do you expect her to have pain and limitations going forward? Yes. Here's some photos. Of course, she's going to need to go through this 2 more times, right? You're going to have to open her back up, take out the clinoid, the whole process, put it all back in. All this stuff, this physical therapy, opening up the scar, sleeping on the recliner, all of these things she's got to go do again. And of course, we don't even know for sure if this infection is going to go away and what's going on for her years down the road. In the past, 2 surgeries, 3 steroid injections, the CT, the aspiration, the replacement, biopsy, 50 physical therapy appointments, 30 doctor appointments already, right? And you know going forward, she's got another 36 PT appointments, more doctor's appointments, and so on.
Yeah, so I can see what he's doing. He's doing a pretty good job. What he's doing is he's going through whatever the jury verdict reporter and the jury verdict in his state allows. See, and he has it up on the board, like physical pain, physical impairment, humiliation, inconvenience. And so the law allows the jury to allow for, or some people say award, an amount for each category. So he has all the categories up there. Some people do it with a screen. He does it with a paper, which is fine. And he's going through it. And you notice he argues, well, even the defense expert says that she's going to have future pain. So now it's almost like uncontroverted, right? Because, of course, our experts, our treating doctors say she's going to have future pain. But even the defense expert, when I asked him, says she's going to have future pain. So now it's like you have to allow for future pain. So that's a very convincing argument. And that's very smart for him to set up the case from the beginning to ask those questions of the defense expert, knowing what the charges and the line items will be at the end of the case.
This timeline we went through, I'm not going to go through it in detail again. However, I think what's key is there's an argument that between the time that Dr. Hartman just saw her in September and the past year, you heard counsel say, oh, she's doing fine, everything's fine for that year until the infection happened. You heard Vicky saying, and her family, this pain has not changed. It's been staying all throughout 2017. Dr. Hartman just said in September 2017, come see me in a year, but you're going to deal with pain. And in fact, when she saw Dr. Downing in December of 2017, he said it's still hurting. And then when she saw Dr. Baer in July of 2017, before, she said, I can't do these things, I can't sleep, it's still hurting. So it's not like things were great all of a sudden in this year before the infection. Nothing has changed in terms of her chronic pain and what was going on. I asked Dr. Hartman, you told her whether or not the surgery is successful in fully getting rid of the infection, is she still going to have chronic pain, even if they get rid of the infection? And he says yes. I asked him, what is chronic pain to you? What's your definition, if you remember that? Chronic is unrelenting and constant, and day to day. That's just the treating physician, no skin in this game, saying that this woman is going to have chronic, unrelenting pain day to day.
Yeah, you see, he also says it's the treating physician, no skin in the game, because a lot of the jurors are going to have biases, right, against allowing for, say, millions of dollars for pain and suffering. That's just a general tort reform type bias, so he's careful about that. He probably already pre-screened the jury in jury selection and was careful to get all those jurors off for cause. So hopefully his jury is somebody who can allow for millions of dollars for pain. But he's saying this is a doctor who's just a treating doctor. He's treating a lot of patients. This just happens to be one of his patients. No skin in the game. And he's saying what pain is and that she will have pain for the rest of her life, and then, put a value on it. So let's see what else he says.
And so I wanted to take Dr. Baer through the history, right? This is her January. She's going to have the surgery. February, the antibiotics. March, the spacer. April, probably get the other surgery. Physical therapy will take her to 36 sessions 2 or 3 times a week. It's going to bring her to Halloween of next year of treating still. And of course, there's a lot of lifelong things she needs. Infectious disease, orthopedic doctor visits, pain medication going forward. This will go on until her life expectancy of about 2040. The 5 to 10 pound litigation, 5 to 10 pound limitation, I would argue that's not necessarily functional if you can't lift more than 5 pounds with your arm away from the body.
Yeah, the other thing I wanted to point out is that, the attorney seems pretty calm. He makes some mistakes, but he just fixes them. He's human, which is good. He's vulnerable. And he also, when he's presenting with the poster board, he might be talking about something else that's not on the screen because there's the CVN, the Courtroom View Network, and they record a lot of these civil trials, but maybe they don't record everything that he's pointing to. But a lot of lawyers, what they'll do is they'll put up a PowerPoint or put up something and then start looking at and start reading it. You don't want to do that because the jury, as long as they can see it, they could be reading it on their own. What you want to do is look at it and comment on it, and and then the jurors will look where you are looking. So if you're looking at the presentation, the PowerPoint, whatever it is, they'll be looking at it and you comment on it, and then you kind of discuss it, and then you move on to the next point. But I think he's doing a good job.
That's not a good situation for any of us. 20 near body, reduced range of motion. It affects your mood, it affects everything, Dr. Hartman said. Dr. Bear agrees she's going to have pain limitations going forward. And you don't know. This infection, we don't know for sure. And that builds a lot into anxiety, stress. Is this thing going to go away? What's in store for me? So for non-economic damages, I told you at the beginning of the opening statement, I believe a fair number for this, when you look at each of these things, which I think we've touched upon through the trial, and given evidence on each of one of these things, not only to rehash everything, I think a fair number for that, $500,000 for everything she's gone through for the last 3 years. I think for this next year, which is a disaster, what's nice about Vicky, she's not a woe is me, she's going to put a smile on and do what she can, but it's going to be a nightmare dealing with this for the next year. So I think $750,000, at least for the next year and a half.
See, now here, even though he got a good verdict, he got a 7-figure verdict, which means it was $1 million verdict. But here I would disagree with him. And see what he's doing? He's saying, I think. Now, it's not about what you think, right? You're an attorney. You're just a conduit, meaning you are here to represent your client. You are here to present a case. So it's not about what you think subjectively. No one cares what you think, you know what I mean? What you have to say is, civil justice in this case is $1 million. And then you explain why. You don't want to say, I'm going to ask you for, because when you're asking, it's like you're begging for money. Then the people are going to be like, you know what? I'm not going to give you that. You don't want to say, I think. You just want to say what justice is. Justice is $1 million. Justice is $500,000. Whatever, and you want to be confident. You want to own it. You don't want to be like, I think that's not good. But he's doing a good job. That's just my little critique.
For these 2 surgeries she's got to go through, the antibiotic spacer and all that, and then when you carry it out for the rest of her life, after this year, I think $750,000 for the next 21 years of her life to deal with the chronic pain and limitations is fair. And that's $1.5 million, so $750,000 for this next year of incredible treatment, and then $750,000 beyond that. There's folks here that are comfortable with numbers, and so we need to think about this as this is a debt that Kroger, Rouse, owes to Vicky at this point. And how do we balance this out, right? What is fair? We can't make her arm 100%, but all we can do in the civil justice system is award reasonable damages for what she's going through and what she's going to need to. And I think one way, we can look at this to make some sense of it. I mean, even if you look at, let's give her 11 minimum wage, right? If you call this is really like a job for her, going to these 80 appointments, dealing with everything that's going on. If you took an $11 an hour minimum wage for the time that she's awake, dealing with the chronic pain and her limitations, and she's got 21 years left in her life, take the $11, times it by 17 hours, so you take off the sleep time. However, she told you she gets woken up in the middle of the night even when she's sleeping. But let's just take out the sleep time. You're at 187 a day. $68,255 a year. You multiply that by 21 years, you're at $1.4 million for her future from today on.
So that's known as a per diem argument, because what he's saying is even if you were to value it for just $11 an hour, and then you multiply that, and then how much that is per day, and then for the rest of her life, and look, it's like 1.4 million, and that's very reasonable, which is a very powerful argument. In New York, unfortunately, we're not allowed to make that argument. Per diem arguments like that, saying what the pain will be worth each hour or each day, is not allowed, and that could be a reason why your trial could result in a mistrial if you say it. So you have to be careful where you are, which jurisdiction.
So I think when you look at it in that, it's really not an unreasonable amount. And I don't know who would trade everything that she's going through for the rest of her life and that the doctors say she's going to deal with for $1.4 million for pain and suffering, $1.5 million going forward for the rest of her life. So again, your verdict form, $10,000 for lost earnings, $20,000, $52,000 for lost earnings. In the future, $282,000 for the meds, $500,000 for pain and suffering for the last 3 years, and $1.5 for all future. I think that's a reasonable amount for everything she's gone through to get her on the right path and to compensate her what's just for everything that's gone on. She did nothing wrong, and I think you'll do what's fair. Thank you.
Yeah, so I think that was pretty good. He did a good job, like we were talking about. And that's one of the ways that your lawyer, if you have a personal injury case and it goes all the way to trial, that's similar to what your lawyer will do at the closing argument, that you have to have all the elements, all the line items that the jury can allow for and explain them, go one by one. Sometimes I like to actually write them out and put the amounts up there and say like $500,000 for this, 1.5 for that, so that the jury sees it all, and then you add up the total. And sometimes what I like to say is, this is like the baseline. Anything less than this would be cheap. Anything less than this would not be justice. This is the baseline. If you feel it's worth more, that's fine. You can allow for more, but this is the absolute baseline. It shouldn't be less than this. Okay, I hope this has been helpful. Let us know what other questions you have. We are here for you. Have a great day, everyone. Bye-bye.